The case for the petitioners is that the second respondent, in exercise of his responsibility as the returning officer of the presidential election, declared the results for the election of president before receiving all the forms 34A from the 40,883 polling stations from across the country. Incomplete results, argued Mr. Otiende Amolo for the petitioners, could not be a basis for a valid declaration. The respondent's answer to that assertion is that the results were declared on the basis of Forms 34B, all of which had been received by the time of the declaration, by the time the declaration was made. In an affidavit sworn by Koitameto Lekina in support of the petition, there is telling correspondence which we had referred to earlier, but which we reproduce in the present context. On the 10th of August 2017, the deponent, acting on behalf of the petitioners, wrote to the second respondent in the following words, and I quote, "Your brief on the above subject at Bomas on the 10th August 2017 at around 9 p.m. refers. You informed Kenyans that and the world at large that IEBC had received over 40,000 Forms 34A and about 170 Forms 34B. We have requested IEBC for all these forms for purposes of verification. Members of your secretariat have informed us that they cannot avail 29,000 Forms 34A as at 11 p.m. of 10th August 2017. We kindly request the Commission expedite release of the remaining Forms 34A and B to enable us complete the verification exercise," unquote. Again, on the 14th of August 2017, the deponent wrote, quote, "This is a follow-up on our letter dated the 10th of August 2017. Until now, IBC has only furnished NASA with 29,000 Forms 34A and 108 Forms 34B. We urgently require the unsupplied 10,000 Forms 34A and 187 Forms 34B to complete the list of documents the Commission was supposed to release to all the candidates in the just concluded general elections. Attached, please find a list of the outstanding 187 constituencies for your immediate action," unquote. On the 14th of August 2017, the Secretary and CEO of the first respondent wrote as follows. "Reference is made to your letter dated the 14th August 2017 requesting to be supplied with the remaining forms that were not supplied earlier. The Commission is in a position to provide all the required Forms 34B immediately. We are, however, not able to supply Forms 34A as at the moment, but the same shall be availed to you as soon as possible." It is a fact that the correspondence quoted above did take place, and the contents of the said correspondence were never controverted. On this basis, a number of questions therefore arise. A, why was the first respondent not able to immediately supply the petitioner's agents with all the Forms 34B upon declaration of results if, as it was submitted, the said results were based on the same, and all of which were said to have been availed? B, why was the first respondent not able to supply all the Forms 34A said to be around 11,000 to the petitioners at 14th August 2017, 4 days after the declaration of the results? C, were all the scanned copies of Forms 34A electronically transmitted to the National Tallying Center simultaneously with those transmitted to the Constituency Tallying Center in accordance with Section 39(1)(c) of the Elections Act? If so, why would it have been impossible for the first respondent to avail those copies to the petitioners? If not, why were they not transmitted in the manner required by the law? We sought answers to these questions as we listened to the submissions of counsel on the emerging conundrum. The submissions of Mr. Nyamodi on behalf of the first respondent made disturbing, if not startling, revelations. According to counsel, the first respondent used Forms 34B as opposed to Forms 34A to declare the final results of the presidential election. He emphasized that at the time the final results of the presidential election were declared, all Forms 34B had been collated. It was counsel's submission that the declaration of Sections 39(2) and 3 of the Elections Act 2011 by the Court of Appeal as being inconsistent with the Constitution curtailed the first respondent's ability to change, amend, or alter the results transmitted from the constituency. According to him, therefore, the decision of the Court of Appeal in the minor KI case extinguished the concept of provisional results. Consequently, the numbers manually entered into the KEMS did at the close of polling and transmitted simultaneous to the CTC and the NTC bore no status in law. They were mere statistics, although, as Mr. Muhati stated in his affidavit, the presiding officer had to show the agents present the entries made for confirmation before transmission. Mr. Nyamodi further explained that the completion of the transmission of the images of Forms 34A was dependent on the availability of 3G and 4G network coverage. In respect of areas lacking 3G and 4G network coverage, the respondents established alternative mechanisms to ensure completion in transmission of the image of the Form 34A. The procedure adopted in the transmission and tallying of results of the presidential election was in conformity with the decision of the Court of Appeal in the minor KI case. On the basis of this process, counsel submitted that the petitioner's allegation that the first respondent deliberately predetermined and set itself on a path of subverting the law by being a law unto itself was unfounded. In addition, counsel submitted that the determination by the Court of Appeal on the finality of presidential election results declared by the constituency returning officer also changed the structure of Form 34C. Regulation 37, subregulation 3B, for avoidance of doubt, provides, as I now read, upon receipt of Form 34A from the constituency returning officers under subregulation 1, the chairperson of the commission shall tally and complete Form 34C. However, the first respondent had to allegedly modify Form 34C to reflect the entry of Forms 34B, which was the form declared by the Court of Appeal to be the source document to determine the winner of a presidential election instead of Forms 34A. Mr. Nyamodi concluded by reaffirming that the way the first respondent structured its transmission system was largely based on the Court of Appeal's decision in the minor KI case, which did not interfere with or negate the will of the people resident in Form 34A. What was Mr. Nyamodi saying? We were left to ask. Was counsel admitting that the second respondent indeed, as claimed by the petitioners, had declared the presidential results without having received all Forms 34A? Was he in the same vein also admitting that not all Forms 34A had been electronically transmitted to the National Tallying Center from the polling centers as required by law? Where did the language of statistics as opposed to results emerge from? Was counsel disclosing the fact that fundamental changes had been made to the KIMS system at the sole discretion of the first respondent without reference to all the players in the presidential election contest? Be that as it may, Mr. Nyamodi persistently argued that the conduct by the first and second respondents, to wit, of declaring results solely based on Forms 34B without reference to Forms 34A, of not scanning all Forms 34A and simultaneously transmitting them to the NTC, of configuring Form 34C to exclude Form 34A tally and only include the Forms 34B tally, of introducing the language of statistics as opposed to results, that all these actions were necessitated, nay, required by the decision of the Court of Appeal in the minor KI decision. We were, on our part, at pains to understand how the Court of Appeal decision in that case could have provided a judicial justification for the conduct of the first and second respondents. The Attorney General, appearing as amicus curiae, having been so admitted, and despite having been clearly restrained from submitting on the so-called impact of the minor KI decision, also appeared to suggest in his closing remarks that somehow the appellate court's decision in that case had changed the landscape of the conduct of elections in this country. In the above context, we reiterate that the main questions that this court has to grapple with at this stage are as follows. A, whether the second respondent declared the results of the presidential election before he had received all the results tabulated on Forms 34A from all the polling stations. B, whether all the Forms 34A had been electronically transmitted from the polling stations to the National Tallying Center. We've read the extensively reasoned and powerfully rendered decision by the Court of Appeal in the minor KI case. We find nowhere in that decision where the learned judges of appeal suggested or even appeared to suggest that by affirming the High Court's decision, which had declared Section 39, subsection 2 and subsection 3 of the Elections Act unconstitutional, the Court of Appeal somehow, for unstated reasons, lent judicial imprimatur to the first and second respondent to either circumvent or simply ignore the provisions of Section 39(1)(c) of the Elections Act. On the contrary, the appellate court's decision was an unstinging reaffirmation, if not a restatement, of the letter and spirit of the constitutional principles embodied in Articles 81, 86, and 138(3)(c) relating to the conduct of elections. And we have shown why that is so. Section 39(1)(c) of the Elections Act, for avoidance of doubt, provides as follows, quote, "For purposes of a presidential election, the Commission shall, A, electronically transmit in the prescribed form the tabulated results of an election for the president from a polling station to the constituency tallying center and to the national tallying center. B, tally, verify the results, tally and verify the results received at the national tallying center. And C, publish the polling result forms on an online public portal maintained by the Commission." Clearly, with this provision in mind, the Court of Appeal in Maina Kiai decision was categorical as it rendered itself, as I quote, "We are satisfied that with this elaborate system, the electronic transmission of the already tabulated results from the polling stations contained in the prescribed forms is a critical way of safeguarding the accuracy of the outcome of elections, and do not see how the appellant or any of its officers, read the first respondent, can vary or even purport to verify those results," unquote. And the Court of Appeal continued this way. "The appellant, as opposed to its chairperson, upon receipt of prescribed forms containing tabulated results for election of president electronically transmitted to it from the near 40,000 polling stations, is required to tally and verify the results." The appellate court had earlier made a pronouncement with which we are in total agreement to this effect. Quote, "It is clear that the polling station is the true locus for the free exercise of the voters' will. The counting of the votes as elaborately set out in the Act and the regulations, with its open, transparent, and participatory character, using the ballot as the primary material, means, as it must, that the count there is clothed with a finality, not to be exposed to any risk of variation or subversion," unquote. Given this very clear elucidation of the law regarding the imperative for electronic transmission of results from the polling station to the NTC, how could the Court of Appeal's decision in Maina Kiai have provided a justification for declaring the results of the election of the president without reference to Forms 34A? How was it a basis for the reconfiguration of Form 34C, so as to render Forms 34A irrelevant in the final computation of the results? But most critically, how did the Court of Appeal's decision relieve the first respondent from its statutory responsibility of electronically transmitting in the prescribed form the tabulated results of an election for the president from a polling station to the CTC and to the NTC in accordance with Section 39C of the Elections Act. At the end of the day, neither the first nor the second respondent has offered any plausible response to the question as to whether all Forms 34A had been electronically transmitted to the NTC as required by Section 39(1)(c) of the Elections Act. What remained uncontroverted, however, was the admission by Ezra Chiloba that as of 14th August 2017, 3 days after the declaration of the results, the first respondent was not in a position to supply the petitioner with all Forms 34A. Counsel for the first and second respondents, by insisting that the presidential results were declared on the basis of Forms 34B, all of which were availed, also implicitly admitted that not all Forms 34A were availed by the time the second respondent declared the final results for the election of the president. In addition to the above, the relevant to this aspect of the petition, pursuant to an application by the petitioners, the court issued an order requiring the first respondent to supply the petitioners and the third respondent with all the scanned and transmitted Forms 34A and 34B from all the 40,883 polling stations on a read-only basis with the option to copy in soft version. Had the court's order been complied with, it would have unraveled the mysterious puzzle surrounding Forms 34A. Regrettably, according to the information made available to the court by its appointed experts, the first respondent only allowed a read-only access to this information without the option to copy in soft version only 2 hours to the closure of the court proceedings, which never fully happened anyway. By this time, however, the puzzle had already been unraveled in the mind of the court, and we shall shortly explain why. In any event, it is claimed in the petition, and IEBC in its response conceded, that 2 days to the election date, IEBC announced that it was going to be unable to electronically transmit results from 11,000 polling centers because they were off the range of 3G and 4G network. Consequently, its officers would have to move to spots where they could get network to be able to transmit. Come the election date on the 8th of August 2017, IEBC claimed it was unable to transmit results from those stations. According to submissions by Counsel for IEBC, such inhibition set in place the use of a complementary system of transmission of results envisaged under Section 44A of the Elections Act, which is in essence the physical delivery of Forms 34A to the CTC, and hence the delay in the declaration of the results from those polling stations. With tremendous respect, we cannot accept IEBC's said explanation. Failure to access or catch 3G and or 4G network, in our humble view, is not a failure of technology. Surely, IEBC's ICT officials must have known that there are some areas where network is weak or totally lacking and should have made provision for alternative transmission. It cannot have dawned on IEBC's ICT officials 2 days to the elections that it could not access network in some areas. In stating so, we note that under Regulations 21, 22, and 23 of the Elections Technology Regulations 2017, IEBC was required to engage a consortium of telecommunication network service providers and publish the network coverage at least 45 days prior to the elections. In that regard, we take judicial notice of the fact that in one of its press briefings preceding the elections, IEBC assured the country that it had carefully considered every conceivable eventuality regarding the issue of the electronic transmission of the presidential election results and categorically stated that technology was not going to fail them. IEBC indeed affirmed that it had engaged 3 internet service providers to deal with any network challenges. We cannot therefore accept IEBC's explanation of alleged failure of technology in the transmission of the presidential election results. The so-called failure of the transmission was, in our view, a clear violation of the law. In any case, in his affidavit, Mr. Muhati, IEBC's ICT director, stated, averred that in polling stations of the range of 3G and 4G network coverage, the presiding officers were instructed to move to points with network coverage or to the constituency tallying centers in order to electronically transmit the results. It is important to note that once the POs who were off the network range scanned the results into Forms 34A and typed the text messages of the same into the KIMS and pressed the submit key, a process IEBC told the country was irreversible. All that remained was for the POs to move to vantage points where 3G or 4G network would be picked, and the details could automatically be transmitted in seconds. As is also clear from the information posted in the IEBC's website, among the 11,000 polling stations IEBC claimed were off the 3G and 4G range are in Bomet, Bungoma, Busia, Homa Bay, Kajiado, Kericho, Kiambu, Kisumu, Kisii, Kirinyaga, Nyeri, Siaya, and Vihiga counties. It is common knowledge that most parts of those counties, have fairly good road network infrastructure. Even if we were to accept that all of them are off 3G and 4G network range, it would take at most a few hours for the POs to travel to vantage points from where they would electronically transmit the results. That they failed to do that is, in our view, an inexcusable contravention of Section 39(1)(c) of the Elections Act. We further note that at the time of declaration of results, IEBC publicly admitted that it had not received results from 11,883 polling stations and 17 constituency tallying centers, that in its letter of the 15th August 2017, IEBC also admitted that it had not received authentic Forms 34A from 5,015 polling stations representing 3.5 million voters. Dr. Aukot, the first interested party in the above context, echoed the petitioner's case that the whole process of counting, tallying, and transmission of results from polling stations to the CTC and finally to the NTC lacked fairness and transparency. That IEBC itself admitted that it had network problems which hindered its prompt transmission of results, but by the time of announcement of results, transmission had been completed. What was IEBC's answer to the above contention? In his submissions before us, Mr. Nyamodi, learned counsel for IEBC, outlined to the court the mode of the transmission process of the results and submitted that after the manual filling in of Form 34A, the POs then keyed in the results into the KEMS kit, took the image of the Form 34A, and then simultaneously transmitted the same to the constituency and national tallying centers. Our understanding of this process is that the figures keyed into the KEMS corresponded with those on the scanned images of Forms 34A. In these circumstances, we do not understand why those figures, which learned counsel referred to as mere statistics that did not go into the determination of the outcome of the results, differed. In these circumstances, bearing in mind that IEBC had the custody of the record of elections, the burden of proof shifted to it to prove that it had complied with the law in the conduct of the presidential election, especially on transmission of the presidential election results, and it failed to discharge that burden. Of further note is that IEBC strenuously opposed the petitioner's application for access to its servers, claiming that such access would compromise the security of the data in those servers. After considering the application, we overruled that objection and partly allowed the same. Though we did not therefore accept IEBC's said claim of compromising the security of its servers, considering the fact that having spent billions of taxpayers' money, IEBC should have set a robust backup system, nevertheless, to assuage those fears, we granted the petitioners a read-only access, which including copying where the petitioners so wished. The report from the court-appointed IT experts, Professors Joseph Sevilla and Elijah Omwenga, holders of PhDs on IT and lecturers in Strathmore and Kabianga universities, respectively, shows clear reluctance on the part of the IEBC to fully comply with this court's order of the 28th August 2017 to provide the information requested. In summary, the following are the items that were not availed to the petitioners and to the third respondent and the court. A, firewalls without disclosure of the software version. IEBC refused to provide information on internal firewall configuration, contending that doing so would compromise and affect the vulnerability of their system. The court-appointed ICT experts disagreed with that contention and said it was difficult to ascertain whether or not there were any hacking activities. B, IEBC was also required to provide certified copies of the certificates of penetration tests conducted on the IEBC election technology system prior to and during the 2017 election pursuant to Regulation 10 of the Elections Technology Regulations